Да, власть не дожидает.
So we have decided to take the authority in our hands without waiting for the Minister of Justice. Taking into account that we've been allocated only 1 hour and 45 minutes for our plenary, and the presentations should last from 7 to 10 minutes each. It is quite possible that the two representatives of the Ministry of Justice have already made their presentations. That's a joke. But as they are not here, we will start ourselves. And I would like, in the beginning, to give the floor to the advisor of the President of the Russian Federation, corresponding member of the Academy of Science of the Russian Federation, Mr. Veniamin Yakovlev. Well, I haven't mentioned all his titles, of course, but anyway, well, too few, but okay, anyway. Thank you. Dear colleagues, I think that we are all under an impression of a wonderful legal forum that has been taking place here in the recent days, and today we will crown our conference with a very good ending. Of course, the civil law comes second after constitution in terms of providing the foundation for the life of our society and our citizens. It is the groundwork for the rights and liberties, for entrepreneurial activities, satisfying the social demands of the society. And of course the discussion of civil law issues, its improvement and further development, has a primary importance. As you know, the current civil code was prepared for 15 years, and 4 more years took to prepare proposals for its amendments. So there was a huge amount of work that was carried out. And I think unlike some other codified codes, this code is quite well constructed. In the early 1990s, as you remember, a state program for the revival of private law was instituted. A private law research center under the President of Russia was set up, where the most outstanding experts were assembled in 1994. A special presidential council for the improvement of civil law was set up. The second and the first, the second and the third presidents of Russia actively participated in this work. What do I mean by the overall concept of up-to-date civil law in Russia? This means the revival of private law as the foundation for private property, entrepreneurial activities, and market economy regulated by law. The program for the improvement of civil law envisages, on the one hand, the development of fundamental provisions of civil law, and consequently the development of freedoms and rights of the citizens of the country, and on the other hand, it means the introduction of better legal regulations in order to overcome certain negative aspects characterizing our economy and law enforcement activities. So the fundamentals of the further development of civil law were formulated in the presidential decree of 18th July 2008 on the modernization of civil law. All the work was carried out in accordance with these fundamental issues. In our proposals, we had to embody the huge experience in the implementation of the civil code, and this experience tells us that some institutions on the whole work quite effectively, but there are some bottlenecks which require our attention in order to enhance the effectiveness of legal regulation. We had to be guided not only by our own experience, but the experience of the development of national legislations in Europe, and the experience of the development of the core of laws of United Europe, which is especially interesting for us because economic legislation of Europe regulates the interaction and mutual enrichment, as I see it, of economic law with the elements of both continental and common law. However, the program for the modernization of civil law means not only the strengthening of private law elements, but also the upholding of a systemic nature of the civil code. And this is a system of logical interconnection between main institutes and institutions of common law, because civil law operates only as a whole, and that means that civil law should always be based on public law, because if civil law institutions are not supported by public law institutions, the regulation of economic relations cannot be effective. So the proposals that are contained in draft law on the development of civil law, on the amendments actually to the civil code, are aimed at further enhancement of freedoms and subjective rights. This can easily be seen in the system of rights related to the in rem part of legislation. In the 1990s, when we didn't develop the section devoted to natural resources, and we were trying to protect property from arbitrary actions, because if ownership rights are infringed upon, we won't be able to stop such phenomena as raiders' activities, that is, capturing of other people's enterprises by force. So all of this is described in the draft law currently under consideration in the State Duma. We were trying to fill in the gaps. We were clearly lacking in our civil law the regulation of financial markets, everything that is related to securities markets. Now we deal with such new instruments as the internet, and we need to respond to this new phenomenon. Otherwise we are going to shift the balance of interests in the field of intellectual property rights. So we need to ensure that the Civil Code of Russia should continue to be the pivotal point of civil legislation. Civil legislation is like the Pacific Ocean, and there should be a coordinating center somewhere. Therefore, our draft law proposes to strengthen major provisions of the main sections of the civil law, as corporate law, as in rem law. You know that in the civil law we have general provisions with regard to intellectual property rights, and we need to make sure that our civil legislation consists of 2 levels rather than 3 or 5 levels. And the first level, of course, well, the Constitution provides the basis for everything, but there are 2 levels: the Civil Code and other sources of civil law, other laws that should be in line with the general provisions contained in the civil law. And only in this way we will be able to ensure harmony in legal legislation. It's very important to strike a balance of interests. Therefore, we have included the principle of good faith behavior of all the subjects of civil law, as well as the application of legal remedies. Of course, we could not but take into account the global financial and economic crisis, and we have included certain provisions related to the protection of interests in this field as well. A lot of attention was paid to the establishment of mechanisms for the prevention of violations. If the civil law cannot prevent violations, you won't be able to rectify that situation with any measures of criminal law nature. Therefore, we are proposing to include certain public law provisions into our civil laws, that is, government or state registration of certain of legal entities, titles to property, some objects of intellectual property, in order to ensure stability and a high level of protection of parties to those relations. We are proposing to strengthen the role of notariate as an important tool to ensure legal security of economic agents. We know how many violations occur in this field with regard to the real estate property rights, whereby weaker people, older people are evicted actually from their homes, and other people take their homes over from them. So here notariate can provide invaluable assistance, as well as in relation to the activities of economic agents. We need to develop the institution of responsibility of founding members of legal entities, so it could become clearer who takes decisions that may be sometimes dangerous for other participants in civil relations and who should be held responsible for such decisions. We have developed a system of measures to enhance the stability of transactions and contracts, so that they couldn't easily collapse when transactions and contracts are deemed null and void on minute grounds. So all of this, such relations could terminate only if certain harm is inflicted upon the participants in those transactions and contractual relations. We have worked out transitional provisions because we need to make sure that new institutions do not create a discomfort in the economic field tomorrow. We need to resolve the issue of re-registration of rights or titles. We need to reconsider the situation with levying and charging of duties. So on the one hand, we should prolong this transitional period, but on the other hand, we need not create unnecessary problems for economic agents. During the preparation of our proposals for the modernization of the civil code, an intensive debate emerged, and in the course of these debates, the whole process of completing this work on time was under threat. And now the ex-president, head of the government, Anatoly Medvedev, asked the Ministry of Justice to take part in the process, and the minister himself, so that they could help to complete the work on the improvement of civil law. The Ministry of Justice, I think, should have participated from the very beginning, but it's still good that it happened at least at the later stage. Certain compromises were achieved as a result. The developers of the code in some had to agree to those compromises. We don't know whether this will improve our legislation or not. So these compromises will be checked in the course of law enforcement activities. We'll see where we were right and where we were probably wrong. The most important thing is that our civil law today was in line with its name. It must reflect the interests of all the citizens of our society, entrepreneurs, consumers of those services that are provided by businessmen. Entrepreneurial activities must be stimulated, but under the conditions that it is in the best interest of the citizens of our country. We should not forget that according to the Constitution, our country is a social state. Thank you very much for your attention.
According to our agenda, now we are to have my presentation. I will have to introduce myself. Starting from 1985, approximately, I have dealt with the civil law, and it has always been the greatest love of my life. And the fact that I participated in the development of the 1994 Civil Code and its amendments is a great honor for me. I have always thought when the imitation of the legal training and legal science that have been successfully employed by our society over the last 20 years will be manifested to the utmost. And with regard to the preparation of amendments to the civil law, I understood that the time for militant ignorance came. How many more law departments should we open, awarding counterfeited law degrees, and then fill up our bodies and companies with false lawyers? At the end of the day, this process should manifest itself. We are only at the beginning of this way, and I'm sure that we are face many more adventures on the way. So the civil code is actually the first sign, the first swallow, because those who received this, so to say, education were awarded a PhD degree, and we will receive from these fake experts a lot of unpleasant things. So actually, in this respect, the civil code had a very difficult life, not only to the extent that the amendments introduced violated the established traditions in the sphere of property relations, and everyone was used to it, even if sometimes they were really ugly and inappropriate. Nevertheless, everyone got used to them, and people wanted to live within the same framework. So that's why they do not want to accept the proposed amendments. And another circumstance that affected the difficult life of the amended civil code is about the impact of economists on drafting laws. Somehow, each person thinks that he is an expert in a specific field, like in agriculture. So they think that if they received a law degree, they can draft a law. But in many ministries, there are no professional ministers. Nevertheless, they commission drafting papers, and they are paid for from the state budget. And what about the law making initiative of the State Duma and deputies as well as the territorial entities. If we were in a European country, we would be very much surprised because actually only the government can initiate a law, only a winning party. In the best case scenario, the opposition may do it and nobody else, but here anyone can do it. So that's why we can't see what kind of the obscure flow of draft laws is passing by us. By governmental authorities can see it quite conspicuously, as well as the Council on Codification, where this draft laws and draft amendments on the civil code come in at a very high speed. So actually, another difficulty is that economists are trying to develop laws resorting to their own definitions and not through legal structures that have been formed over decades. And it is difficult to explain to them why it should be this way and not the other way. To understand it, you need to have a proper 5-year course in law, then go to a school of law and so on, and then you end up with the understanding of why it is necessary. Since we are living in a condition of permanent chaos and immediate changes, so no one cares and no one has time to think about the doctrines that underlie the standards of the civil code, and to translate them as applicable to their own objectives. So the second difficulty was about it when preparing amendments. And the third difficulty, what is about the impact of the Anglo-Saxon law and the interpretation of the Anglo-Saxon law on the existing code. We may talk at length about the convergence of legal systems, but it is not taking place, and probably it is not plausible at all, because the mentality of lawyers operating under different legal systems differs a lot. So we have seen many times that Anglo-Saxon structures and provisions are not applicable in our reality. Let me remind you of Yeltsin's decree on trust that had very unfavorable implications for our economy. Let me remind you about collateral-related auctions that were carried out based on these Anglo-Saxon approaches. Are you really favoring those auctions now, when the most valuable assets that belong to the government ended up in the hands of our oligarchs that always imbibe in everything? And we can capitalize, we can follow up on that. In principle, the impact of the Anglo-Saxon law is happening not on its own, because specific experts are very active in preparing a proposal, in carrying out experts' activities, in impacting our liberal economists, thinkers, because it is well known that the most well-known school of economic liberalism is located in the USA, and obviously our economists are subject to the impact of legal messages that are rooted there, and they try to embed these provisions into our codes too. at a very high speed. So actually, this was the last organizational obstacle on amending the civil code. And by the way, it was a prerequisite for a number of compromises that have been mentioned before. To tell the truth, I'm not very sorry about these compromises, because I think that actually, in the end of the day, these norms will die away, despite the fact that they have been incorporated in our code. It does not make sense. I will make several examples. For example, authentication in the contract law rules. We have introduced them. What are we going to do about this this notification and assurances and guarantees? And what are they going to do about these guarantees and assurances and warrants? Of course, he provided a list of such guarantees and he deceived everyone, but he doesn't have money to cover the debt. Moreover, no money to pay fines, losses, or to introduce any amendments, because actually our society is in a different stage of development. Honesty hasn't become our economic principle yet. So dishonest people do not lose anything in terms of their relations in the society. So how the mechanisms of assurances and warranties will work under such circumstances is absolutely unclear to me. To enable it, then you must introduce criminal liability for fake assurances and warranties. What are the mechanism for imposing sanctions can we use? Otherwise, none. Any of the novelties offered within the framework of the Anglo-Saxon law can be analyzed from this point of view. So they wanted to introduce it. Okay, let's do it. I don't see serious obstacles, but it would not work, I'm sure, by 95%, because Anglo-Saxon provisions and doctrines are hardly applicable in our society, because they were elaborated for absolutely different purposes. So counting on Anglo-Saxon standards in terms of providing a wonderful financial international center in Moscow is not appropriate. In my opinion, that won't have any impact on the formation of the International Financial Center. Well, you know, it is quite typical of many economies to exacerbate the meaning of law in implementing the economic concepts. They think that if they change a law, immediately our economy will start flourishing and it will be prosperous. No, this is not the case. Economic relations must be changed in other ways. You need to motivate, you need to create stimuli for millions of people so that they behave in a certain way. Only then an economic model will be operational. But through changing a law, you won't be able to achieve anything. I keep on saying it, but economists won't listen to me. Well, it is easy for a minister coming into office to announce a wide range of reforms, to write a law, say that I have met my promise, but you know, when outcomes are checked, the term has expired, you have no one to put forward your claims to. So actually, the outcomes are checked only after 5 or 4 years. Well, after a year or two, you may say, well, it has been such a short time, it hasn't worked yet. But after 5 years, it is time to leave your office, so no one is responsible. So new draft laws that are currently submitted will produce a lot of funny stories, and actually I don't believe their feasibility, because you cannot change economic relations in such an easy way, because otherwise our society would be a completely different one, not unlike the one that we have now. I would like to grant the floor to other participants. Maybe I haven't mentioned specific in-RAM law related issues, but we do have a round table on it, and I will take the floor there. And now I would like to grant the floor to Alexander Markovsky.
Thank you very much. Could you move the mic a bit closer? It seems to me that now at the final stage in the development of our civil code and modernization rather of the civil code, we should once again state our goal. What is the purpose of this entire work? We easily use the word modernization of the civil code. Maybe the developers themselves use this word because the real title of this law is too long, and you know, there was a need to find a brief description of this process. It seems to me that the word doesn't reflect too much in terms of the gist of what is happening. I once again was persuaded in it when I read an article by my colleague in the Law magazine, in Law Journal, and he says there that if we are honest with ourselves, we have to say that our civil legislation is still Soviet in many aspects, and now we are undertaking an attempt to do something that needed to be done as far back as in 1995. I do know where Dmitry was in 1995. He was not yet a student of the Russian private law school. Probably he was still in the secondary school at that time, so he's not definitely to blame. If so, there is an expression: if only I were as clever as my wife was later. Well, if we were cleverer at that point in time, we would be able to avoid many things, including collateralized auctions that were carried out, or pledge auctions. Unfortunately, one of the largest law firms over these, not a single law firm was observed as a participant in the process of improving our civil law. But on a serious note, what are we doing now? This word, modernization, covers 4 tasks that have to be resolved in 4 different ways. As Dr. Tikhomirov usually says, there are 4 sets of issues, 4 sets of problems, and those problems are different, and the ways to resolve them are different as well. First of all, you know that the most battles were fought around corporate law, around legal entities, commercial legal entities, of course, first and foremost. But what was the reason behind these novelties? Well, here in the Civil Code, as I see it, in the beginning, in the 1994, a very good groundwork was laid for the development of our corporate law and our law on legal entities. There were mistakes, of course. They're well known, especially the overlapping nature of closed joint stock companies and companies with limited liability, but those were mistakes were more or less okay. But then chaos ensued when those first 2 laws on limited liability partnerships came into being, those two laws were quite acceptable. But what happened next is beyond any logical description. I mean, the provisions of those laws that were changed, there were about 370 amendments introduced to those laws. There were instances when the amendment was hadn't yet entered into force, and it was already abolished by the next amendment. How can we talk about the development of this legislation in such a situation? Non-governmental organizations, you know full well that today there is not a single person who would be able to tell how many organizational formats for NGOs exist in the country. There is an attempt undertaken now to rebuild the core of legislation on legal entities. And another thing is in rem legislation. Here we still are living on the basis of Soviet legislation. When this section of the Civil Code was developed, very few people, maybe Igor did, but very few people understood that we need to streamline the in rem rights system. The list of such rights was developed. It was like an additional, decoration, but so we're talking about servitudes, about other things, but really the system didn't start to work. We kept such in rem rights as collective management, indefinite use, and in the field of real estate, in the field of land, we still operate with such notions with title and lease, and that's it. We cannot build such relations on such a fuzzy foundation as lease or rent. We need to have something much more solid, and here an attempt is undertaken to create a real system of in rem rights. Anton played a very important role in the beginning because he actually introduced the system of in rem rights. Now, general provisions of contractual law. Dmitry is saying that we need to open the window, we need to let in the wind of self-regulation, and everything will be just fine. And if you look at the amendments that are introduced into the existing civil code, its third section, those amendments are of a different nature. They are moving us towards strengthening contractual discipline. That means higher responsibility, additional sanctions, additional remedies related to the compensation of damages, sanctions for participating in negotiations not in good faith, and here we are guided by a wealth of experience and case law amassed by courts of arbitration. Our civil law is developing in this direction now. As far as it would be very difficult to make these provisions fully dispositive, because it is a utopia. The presumption of the dispositive nature of all norms of contractual law. So no one has tried to apply this idea in a consistent way. And the fourth problem was a totally different one. And this was a predictable problem, predictable at a time when the section number 4 was adopted. Remember all those battles that were fought around part number 4 of the civil code? Some people thought that there was no need to introduce part 4 at all. And here we can concentrate all rights of intellectual property in a single codified law. But still, when Part 4 was adopted, nobody thought about the most general of all problems, whether intellectual property is to come into being or not. It is probably still looking a bit differently, but the idea is whether to protect this property or not at all. Of course, those problems are difficult to resolve. We need to talk about the restrictions of protecting such property rights. We are bound by all sorts of international conventions and agreements, and this probably is the toughest problem related to the modernization of the civil code. Here we need to understand the complex, the multifaceted nature of what we are now trying to do along the lines of modernizing the civil code. Thank you very much.
Спасибо.
Thank you. And I would like to give the floor now to Yuri Tolstoy, academician, my teacher, but most importantly a person who is always critical of all the processes of our public life. Dr. Tolstoy, you have the word. Can you hear me at all? Shall I move closer to the bike? Okay. My hand is not well, but anyway. Dmitry Medvedev, in his address at the plenary session of the forum, urged us to be critical during this forum. And I fully agree with this position. So I am fulfilling the instruction by the President. Criticism and self-criticism are the driving force of development, as is often said, and I will focus in my presentation on mistakes, including my own mistakes. But I would like to start with those mistakes that were committed and are still committed by the leaders of the state. And here I will argue with Dmitry Medvedev. Unfortunately, sometimes Mr. Medvedev, in his statements about the prospects for the development of our legislation, is not always consistent. I remember that in the beginning he was quite skeptical about such organizational format of a legal entity as state corporation, but very soon his attitude towards them became kinder, and state corporations started to be perceived almost as the main lever for introducing innovations. I do not fully agree with that, because so far as I see it, state corporations act as behemoths which eat up lots of government money. In particular, the scandal that happened not long ago in Rosatom, Russian Atomic Agency, and it is headed by one of our former prime ministers, and this scandal is a vivid confirmation of this fact. Another issue that I would like to talk about is not directly related to Dmitry Medvedev. I will leave him alone for a while. This is our attitude towards confiscations. Not long ago, confiscation was removed as an additional sanction, additional criminal sanction, and many civilists thought that this is an instruction. This is an instruction meaning that there shouldn't be any confiscation in the civil law. Very often, confiscation was reinstated in the civil law, although under in a slightly different manner. And lawyers cannot make sense of the seizures or confiscations as they exist currently. And this is confirmed in the brilliant article by the late criminal law expert Boris Volzhenkin, which was published in the Legal Studies Journal.
The next issue, and here once again I must refer to Dmitry Medvedev. Quite recently he put forward a thesis about the so-called unknown returns, unknown incomes. So, well, you do know that we do have the notion of illegally obtained incomes and incomes received not through labor activities. So what is unknown incomes? So the name itself implies that no one knows what incomes these incomes are, and the second, which is more important, no one knows what to do about them and with them. So not only scientists, not only public figures, and Dmitry Medvedev is not a scientific person, but he is also a public figure, and actually I foresaw that he would have a splendid professional career, and I'm sure that he will achieve very impressive results. And actually his final statement testifies to it, the one made at the plenary session, and it will contribute to his development as a science. And now I will talk about my own mistakes. Two of them. I was quite enthusiastic in due time about the multi-level character of state property. I was trapped by it, and it seemed to me that if we recognize the multi-level nature thereof, we will be closer to the public, and it will not be entangled in bureaucratic ties that impeded its development. Unfortunately, it did not happen. Vice versa, a huge number of bureaucrats, not only at the federal but also at the regional and municipal levels, thought that it was they who were the actual owners and can do anything about properties. Besides, it gave rise to a huge number of debates pertaining to the sharing of powers between St. Petersburg and the Leningrad region, Moscow and the Moscow region, St. Petersburg and the Russian Property Agency, and so on and so forth. So it seems to me that our teachers probably were not completely wrong when they defended the integrity of the state property inventory, because at that time all the issues were addressed in a very easy way. In the 1930s and 1940s, a set of regulations and bylaws was adopted pertaining to the conveyance of buildings and premises to factories and plants and so on, and it took just 5 minutes to settle an issue. A head of enterprise would be summoned to a head of the Communist Party unit, and they were informed about a certain opinion, and when they were wondering what it was about, it was enough to state that there is an opinion, and an issue was settled without any disputes. However, it should be mentioned that so far an issue pertaining to whether a state corporation is a property owner and what title of ownership it hasn't been resolved, because under the current legislation this property cannot be classified either as private property because it's a state corporation, nor a constitutional property because the Constitution contains an exhaustive list of state property. Neither can it be classified as municipal property. As for other types of properties, they are not applicable because they are non-existent. As private, state and municipal types of property are exhaustive types of property. So probably it is necessary to have a sort of top-up in the form of a public property, which was offered and is offered now by Yevgeny Sukhanov. Another mistake of mine is that I was very enthusiastic about privatization of residential stock, without understanding that millions of our citizens were not ready at all. We forgot, including myself, because
мы наплодили громадное количество.
That free cheese is only in a mouse trap. So as a result, we have a huge number of poor owners who don't know what to do about their assets. Besides, we created an unprecedented layering in terms of the legal regime with regard to properties, because, for example, in a so-called communal flat, one is owned, another is rented, another one is leased in a specialized way, and so on and so forth. To say nothing about the deep social layering apart from the layering in the legislation. Certain residents of a building don't know what to buy more, and others don't know how to feed their children. So just think, how can we provide for an efficient management of this residential building stock? So I'm introducing a radical proposal to hand over multi-apartment buildings immediately while preserving the existing title of ownership to governmental authorities, because partnerships of residents are nothing but a transformation of what was described by Bulgakov in his famous work Dog's Heart, because once again I understood that it was a genius because he wrote it 90 years ago, because actually these partnerships are actually the same type of structure as described by Bulgakov. Well, in the horrible 1937 year, most of the people present here do not remember it, of course, nevertheless saw an adoption of a very important regulation of 17th of October 1937 that actually eliminated the residential leasing cooperative committees. They were abolished, and actually the stock was handed over to a special management body. So at that scary year, at least one relevant regulation was made. So now I'm for such a proposal, though in due time I made a mistake and I was for the extension of the privatization period. And the last thing I want to say about is that everyone must think what kind of repercussions you are going to have when saying something. And it is true with regard to scholars. It's my concern when I see amongst corporate lawyers the dissemination of the theory of fiction with regard to a legal entity, because this theory allows us to justify anything. The Pope of Rome, that in the 13th century founded this concept, did not foresee any implications, because if a legal entity is a fiction, we can set up shell companies that will disappear next day. We can avoid taxation, we can send our assets to offshores, and so on. Another very dangerous trend is that, especially amongst law theory experts that are engaged in political studies too, an opinion is widespread with regard to the clear difference between a law and law. And if there is a collision, then a priority should be given to law. And it is a very dangerous trend, because it is in the opposition of a law and law that they try to find justification for the shooting down of the parliament and shelling of the parliament that was elected in a legal way. Yes, the president is empowered with a lot of prerogatives, and that is one thing, but in terms of law, such an action is quite legitimate. And I would like to say that I'm quite skeptical about the idea of introducing case law as a source of law formation. In my view, we are not ready to it. At this stage, it would be great if we know how to apply legislation. But if we are introducing case law, we don't know where we will end up. And sometimes to justify the case law, two arguments are provided for. Namely, that the lawyers community is more prepared to lawmaking than our deputies. But if our parliamentarians are not ready to lawmaking, why do we need them at all? and it is in conformity with a statement by the former chairperson, fortunately the former chairperson of the State Duma, because he said that the parliament is not the best platform for carrying out discussions. And it is interesting that not long before that statement, that would be part of the history of parliamentary development, he had been awarded a degree of a PhD degree of political studies. And we need to say that judges are less corrupted by parliamentarians. Parliamentarians are corrupted, they are connected to lobbyists, and though judges are corrupted, but at the same time, not to the extent the parliamentarians are. They are not suffering from such tumors. So I'm not in the position to judge which of them is more corrupted. But as for persons that have committed sins, I think we have many of them in both the branches of power. And in conclusion, and sorry for delaying my presentation, I would like to quote one scholar that I respect as much as Veniamin Yakovlev.
I think that in our legal studies there are only two people who are respected by everyone unconditionally. Although one of them is not even a member of the Academy of Sciences, and the other is only a corresponding member of this organization. And I would like to give you a quote from a scholar who is not an academician, but I would like to remind you that Mendeleev, the chemist, Lobachevsky, the mathematician, were not members of the Academy of Science, and many of those who were members of the Academy of Science are long forgotten. Well, frankly speaking, I think that I belong to the second category. So this is the quote. Unfortunately, we cannot say that the level of the development of our civil law is up to the challenges of the present day. Entrepreneurs often demonstrate their decision by moving their legal entities and contracts away from the Russian jurisdiction. Of course, an important role here is played by the law enforcement practice, the condition of the judiciary system. But for that, we first and foremost need a solid core of legislation, because today's situation is similar to the situation in fishing, where fishing boats are usually operating under flags of convenience. We cannot put up with this, but we cannot resolve the problem by bans alone. Our legislation must become attractive for the first time, so that it is seen by its users as a good for which it is worth to fight a fight, to wage a fight, and which can be proud, of which one can be proud. And in conclusion, I would like to support the idea that was expressed by Mr. Yakovlev. The Achilles heel of all our codification attempts, including the work that has just been completed, is the fact that we haven't been able until now to strike the optimal balance between public and private law provisions. We still don't understand that these provisions must function together in a concerted way. And from this standpoint, we need to overcome our misconceptions, and we need to understand that the groundwork for codification work should be should be not the part of law but of legislation that is comprehensive and must be comprehensive by definition. If we become cognizant of this fact, we will move further much more successfully. One last thing, that's the third last thing we are trying to say. Okay, I will complete soon. Unlike many others, I should not scrap, and I wouldn't like to see unitary enterprises scrapped. State-owned enterprises will continue to live for a long time. In Russia, we had wonderful railways that belonged to the state, and we had wonderful state enterprises that were in operation, and many of those are now included into the military and defense complex. A scholar that I was quoting is the esteemed Valery Zorkin, who, as you know, not long ago was re-elected with striking unanimity by the Council of the Federation, where he was supported by all the branches of power. Only one member of that council, and I know, or I guess who it was abstained when he was re-elected as the head of the Constitutional Court for another term. I would like now to give the floor to Yevgeny Sukhanov, one of the prominent fighters for the purity of civil law. I always agree with Yuri in that you cannot develop civil legislation in a sterile environment. You know, all this stuff about real estate, intellectual property, there are many layers of administrations, and the fourth part, well, we know full well all this. Dear colleagues, first of all, I would like to point out with satisfaction that our legal forum has gradually evolved into a civil law code today, and this probably is the right approach, and this happened because the civil law is the basis for legal studies in general, and it defines the development of the rest of the legislation now, which is also good. And from this standpoint, I would like to briefly touch upon the section on legal entities that provoked most of the arguments. This happened because well, many people who read these documents stopped reading the legal entities section, and they never read anything about in rem part of the law, and there were no comments for about a year about the in rem section, but probably people failed just to read the document to the end, and now we are getting more comments about the in rem part than about the legal entities part. As far as legal entities are concerned, this topic is worthy of a special attention because many comments were to the substantial provisions, but this section, as many other sections of this project, is characterized by the following. First of all, we have a combination of some academic theories and, on the other hand, purely practical considerations. About half or even more of the participants of this project were people directly related to the judicial practice and arbitration practice, first and foremost, and many of the provisions are not just a result of theoretical thinking. This is something that popped up in the practical work of our courts and arbitration courts. Those are considerations of a purely practical nature, and here we are dealing with the combination of theoretical, academic on the one hand, and practical provisions. And here this is especially evident in the legal entities section where such issues as the establishment and termination of legal entities, those are practical matters. I would agree with Anton, and probably this complaint should be addressed to us and our colleagues. Over the past several years, we've seen a lot of theses and dissertations, and leaving for St. Petersburg, I saw another stack of dissertations. In May we had 30 or 40 dissertations defended, but out of them 28 are not worthy opening up at all. You just can read the title and send it away into the. You can deposit it into the waste paper basket. Well, vindication of non-documentary securities. We were trying to overcome this problem for 20 years, but no one writes about such things in the dissertations. They're just beating about the bush for 20 years and nothing more. And I'm ashamed, actually. I'm ashamed for our legal science. Well, this section is also characterized by the compromise that was mentioned here before. This compromise is not an all-round success. Though the authors and their opponents disagree on many points, and our opponents were mainly the Ministry of Economic Development, and of late we have seen yet another circumstance. We haven't been able to take into account the interests of the business community, and I heard about that in the Russian Union of Entrepreneurs and Industrialists. Mr. Shokhin, the chairman, is telling us, why haven't you invited us? And how about the financial center that was part of this process? And it turned out that they are just a group of experts who do not represent the business community. And now businessmen, the oil companies, the Russian Union of Industrialists put forward criticisms to us, and their proposals are similar to what we had proposed and tried to fight for in the Ministry of Justice. So this compromise is kind of strange. It is not consistent, and I hope that our Parliament will probably improve upon our work about offshore companies. This section was excluded, and now the Committee on Property is saying that we should reinstate them. And the provisions on controlling offshore companies are included into well-developed European bodies of legislative law. In 2001 in Italy they included a whole chapter on offshore companies. We very often refer to foreign experiences, but there are a lot of misconceptions here still. What we want, we put it to the forefront. What we don't want, we hide. So there were lots of arguments about statutory capital, authorized capital. Big businesses are not worried about that. They understand that companies should not be empty of their funds. Let's do it in America, in the state of Delaware, in the state of California. Nobody is worried about that. If a company wants to pay out dividends, its directors, under the threat of administrative and criminal responsibility, should ensure that the ratio of pure assets and debts should be 5 to 4. That's the direct law in California. Let's take this experience on board. But nobody said anything like that. While we were fighting these battles, the law on economic partnerships was adopted, and they have nothing to do with limited liability partnership or limited liability companies. We invited prominent English lawyers. We invited also representatives of the Ministry of Economic Development, but they never came, and they told us the British partners, they told us that what we invented have nothing to do with LLC or PLC. We invented something that doesn't exist, either in the state of Delaware or the Isle of Man. Against, we are ahead of the entire planet and not in the place we wanted to be. Foreign experience, of course, should be taken into account, but you need to study it seriously. And when, in the course of these debates about legal entities, when I had a chance to take a look at the Anglo-American system, I found many useful things there. But we tend to forget this, but that if you take a single institution from another body of law and then implant it into our body of law, it will make no sense, because their whole system is in operation, combining civil, administrative and criminal law. Well, you need to assess the real assets of a company. How can you do that? With the help of the legislation on accounting records and reports. Anton Ivanov is telling us that the director says that his solvency test is okay, and it is not okay, and he gets 150 years of jails. That's a good sanction, I think. We don't have sanctions like that, but that's the experience of the state of Delaware. If we take the US law, let's take it in its entirety. If you think about that, you will understand that our law is European, it is continental, and Alexander here is right. Those changes that were proposed by IFC and all those provisions that were imposed on us about the responsibilities and rights and freedoms of directors, this is not freedom. And again, I have to say that this is far from being easy. And finally, I think we have selected a more or less balanced approach, although certain options are still possible, and maybe the legislator will improve on our work and correct some of our mistakes. We need a balance of interests of businesses, both large and small, citizens as consumers, and nobody remembers about them except for us. No consumers were ever involved in the process. Public interests must be taken into account. It is up to you to decide whether we were able to strike a balance or not, but probably we have achieved something. And one more thing I would like to say about legal entities.
Somehow it was bypassed because everyone started talking about joint stock societies and corporations, and we forgot about a huge sea of non-for-profit organizations. So it is required that as separate types of legal entities, we included farms, Kazakhs, communities of ethnic minorities, and so on and so forth. If we open up such a door, and we have already received letters from trade unions that a trade union is a type of a legal entity, so here actually we would capitalize on foreign experience. Why in Germany we have also a union of fans of canoeing and Islam and so on, but the legal entity form is only one: Verein, a registered union. Whether they are stamp collectors or whether they deal with politics, doesn't matter. We deal with a legal entity. Is an institute, in our opinion, of the civil law. Many colleagues have stated that a legal entity is a sort of general sectoral association. If it is such an entity, that means that a trade union, a political party, and anything else is a legal entity. But if this is a legal entity, is actually part of civil law, and it is part of property turnover, then we must say that you are numerous. There are numerous regulations, and we don't touch you at all. But as for property relations and so on, this sphere is regulated by the civil law, and nowhere in the world we have 40 types of non-for-profit organizations. 3-4 types is absolutely enough to enter into civil relations. As for other relations, public relations, and here we differentiate the public law. Yes, we have Kazakhs communities, ethnic minorities communities, religious organizations in their diversity, and so on and so forth. But in terms of civil law, we need to provide for unification. We are faced with these issues, and it's quite a serious challenge because lobbying and pressure are exerted on us, but I hope that the system of legal entities will be streamlined. And the last thing that I want to mention is that this work is very hard and it takes a lot of resources and time, but it brings you satisfaction, and I'm happy to say that we have managed to include in the code that corporate relations is a subject of civil law. So that means that many intra-corporate issues, not only in-house relations inside corporations, can be regulated based on clear legal notions and definitions. If we are unclear about these corporate relations, these debates will be endless and we will never streamline the situation, while we do need a certain level of order. Unfortunately, during the last forum, it was mentioned that we need to have a super liberal civil code, as stated by the head of the working group on the civil code development, because this is the only thing that we can offer to our foreign investors. If foreign investors are serious, then such a super liberal legislation won't be satisfactory for them. The control is tightened both in the US and in the UK, and this entrepreneurial foam has actually been moving to us. Do we need it? Is a huge question mark. So I don't think that we really need to liberalize the civil code as much as they want. Thank you. I would like to grant the floor to the Deputy Minister of Justice, Mr. Yuri Lyubimov. Thank you very much, dear Anatoly, dear colleagues. You know, I will take the floor in several capacities, because whatever topic I'm discussing at this forum, it is difficult for me to forget about my capacity as an organizer. So I'm really pleased now that on Saturday morning you decided to have such an unusual time on a weekend to come here to discuss theoretical, abstract ideas is a valuable thing. Well, this topic is very interesting and is very urgent. To tell the truth, I did not think that on Saturday, on the third day of the forum, that when most of the guests already are leaving, we will have a full room. Well, actually, the discussion of the civil code has been discussed in different formats, but we have never had a chance to discuss it in such a beautiful building, and never has the discussion of the civil code been so physically tough. Now, as for the text and the work itself, the Ministry of Justice joined this effort at the very late stage when the deadlock situation popped up because of the tough stance of the Department of the Ministry of Economy and the position on IFC. That served as an impediment on the way of preparing this document. So we were invited to boil down to minimum the contradictions that had emerged amongst the participants. So we are rather an outside observer rather than a fully fledged participant of the process. So we are not claiming to be one of the developers of the code. However, since we are associated with this text recently, I have been communicating a lot on the topic of the modernization of the civil code. Some people praise it, many people don't like it at all, and others wonder why this team specifically has developed the code. And here I can give you a simple answer to this question. However hard we may criticize the text of the code, the team that has developed it is actually the only team in today's Russia that has been capable of putting together an integrated text that would not be written with the customer's budget. I would formulate it this way, because we have a lot of people who criticize this text, and part of the criticism is absolutely irrelevant. This is exactly what we came across when organizing this forum. Too many people want to speak, but only specific persons are capable of putting together a round table, invite high-profile speakers, and create a multi-level product. And the situation is the same with regard to the civil code. There are many people who are ready to amend an article. There are fewer people who are able to amend a chapter. But fortunately, the persons that are present here, and actually the team of developers of the code is wider. But these were the people who have succeeded in creating an integrated large product. Another thing I want to talk about, and I think it was a mistake of the developers, and I'm frank about it because really I respect the developers team a lot. We were trapped by the same thing that existed when the fourth part of the civil code was developed. When in the Soviet time a person was buying a car, they were so fascinated about a metal body of the car because it was covered with a special piece of cloth to protect it so that no one with dirty hands could touch it. So, but however hard you are trying to hide the code from critics, the critics of the code won't disappear. When I was trying to find the code at the website of private law, it took me 20 minutes with the help of 3 assistants, because actually it was part of the resolution of one of the council's meeting. It was not on the front page of the website. It was really hidden, and unfortunately all the people that at a certain stage were not allowed to participate in the toughest discussion with regard to the text of the code. These people now are making their large circles around the government, and they are going to carry out a marathon race around the State Duma. Please believe me that the Ministry of Justice daily receives a huge volume of spams that actually is diverse in the opinion of the people who initiate it, but actually it's absolutely the same in terms of the content. It is of no way different from the comments that were provided by experts 2 or 3 years ago. Similar comments we are receiving from business communities, organizations, political parties, NGOs, whatever institutions. And tomorrow, the same comments with the same content, untouched, will end up at the second hearing in the State Duma as deputies' amendments. So the mistake we made, to my mind, is that we tried to narrow the discussion of the code as much as possible. You cannot discuss the economic constitution of the country with a limited number of experts from the International Financial Center or from the working group of the Ministry of Economy. So that's why many people think that they were deceived and they are offended, because they ask me why they missed the discussion of the code. It happened because we failed to set up the same format of discussion that we have today. And then I'm absolutely sure that many comments that are of concern for people who want to have a say with regard to civil code actually were eliminated 2 or 3 years ago. And the same happened with regard to eliminating opposite opinions between the Ministry of Economy and the IFC and the developers team. So when we initiated this work, we didn't count on success, even partial success. But we started meeting. We sometimes dedicated 2 or 3 working days a week. We rallied in the Ministry of Justice, and we, I think, utilized a plantation of tea and huge numbers of chocolate boxes. Well, success is in compromises. At the end of this effort, I personally participated on a more limited basis in the discussion. And there were several meetings when the Ministry of Justice representatives were not participating in the meetings. And our colleagues, who actually before that hated each other, managed to achieve a well-elaborated compromise. So we started joking that probably there was a lack of microphones and there was a lack of premises, there was no conference interface appropriate to the occasion to be able to eliminate such pending issues. So it seems to me that it is very important to provide people who are not satisfied with the code to express their opinion. It is really better than facing the situation when they have their expectations unsatisfied. The modernization of the current civil code made me believe in reflections by Tolstoy on the role of personality in history. If we look at mass media quoted opinions, we will see that most of them relate to corporate law. But for Ivan Oskolkov and some other experts, probably no one would have remembered about this corporate law, because our civil code is not boiled down to corporate law exclusively. There are dramatic changes in the civil code, and there are many more important things, in my opinion, in corporate law, and they haven't been given appropriate attention yet. Well, the first hearing was successful, and I'm sure that during the second and after the second and the third hearing, the draft will be adopted. But there is a sort of top 10 of amendments that evokes the largest interests. And it is clear because from our favorite mass media journalists, people knew about it. But the thing is that many people who criticize the code have not read the text of the amendments in full. At the same time, they are very important. They create a sort of bottom line for the 15 years of enforcement in terms of law, and it is a huge effort of the people who have been working for a number of years at the text of the code. So it seems to me that the effort made is huge. Real changes that need discussions are beyond the blocks that are currently debated in the most heated way. And I'm grateful to Veniamin Yakovlev, first of all, for the possibility to return to my specialty. Because of my official position, I had to forget about it. And I wish you successful discussion and all the best to you.
I would like now to give the floor to Natalia Raskazova, head of the Department of Civil Law of St. Petersburg University. Thank you very much. I will be extremely brief. I'm the last speaker, and of course I will criticize as the last speaker for extending this discussion beyond the time limit. I will only describe 3 issues that seem to be the most important for me. They are the most important for me because of the processes we're currently involved in. If we try to streamline and categorize all the criticisms that have been voiced about the draft civil code, if we summarize all the proposals, we will be able to subdivide them into 3 groups. Number 1 will be criticism from those who are for free competition, and others come from people who try to preserve regulatory nature of private law. If we are guided by strict logic or emotions, you can successfully argue for or against any point, but the final criterion should be the experience which we have. Yesterday, at the meeting of the round table devoted to notariate, this issue was discussed with regard to the proposals to reinstate notarial handling of real estate transaction. And we received a clear answer from our European colleagues, and there were representatives of Spain, no Spain, Italy, Austria, Switzerland, France, Germany, well, many European countries were present at the round table. I'm not going to I will read out the answers that we received. Mr. Decor, head of the International Notaries Union, quoting one of the Euro commissioners, said that the principle of free competition is not democratically legitimate. Our moderator, Madame Frezon Roche, professor, a French professor from one of the Paris-based universities, and apart from private law, she deals with issues of economic effectiveness, and she said, today nobody believes in pure competition. No one wants to pay such a scary price for ideologization of competition. We cannot but take this experience into account when formulating the provisions of our code. It would be an unforgivable mistake. Another issue that I would like to say a few words about is related to numerous complaints about the existing code and the draft code that we are currently which is currently under discussion. Well, and here I cannot but quote a phrase well known to the majority of people here. Devastation happens not in the civil code but in the heads of people who apply it. All practicing lawyers will probably agree that the principle whereby everything is allowed if it is not prohibited is very difficult to implement in practical terms. People tend to be scary of many things. One of our colleagues remembered those pledge or collateralized auctions that we had in the 90s, and now I'm talking about the law on collateral, which has just been amended. Now we have a provision whereby parties to a agreement on collateral can include conditions on several ways to sell the collateral. And why this provision was not in place? Was it not possible to do so, to sell the collateral in many ways? It was not possible because the courts were afraid, the holders of collateral were afraid, and that's it. This is what criticisms boil down to. We shouldn't just think about how to word a provision, but we need to somehow analyze how we understand the law today, how we apply it today, and if we do not, if we don't stop viewing the law as a step-by-step instruction, we are not going to move further. We need to study the logic of present-day law, its principles. Today, Europe, which is developing along these lines, is proposing a lot of instruments aimed at better understanding of these principles. I mean, model rules worked out by the working groups of the European Union as guidelines for national legislators, draft common frame of reference. This is a very interesting document which was a fruit of long-standing work by Europe's leading lawyers, and the main value of this document is not that it contains concrete specific provisions with regard to main components of private law. It is valuable because it helps to understand the spirit of modern-day private law. This document hasn't yet been translated into Russian, but our Department of Civil Law at the university has prepared translation. We are now editing it. It is in the final stages of preparation. It is a difficult task, a daunting task, because you need to translate it not from English into Russian, but from legal English legalese. This is a language that is spoken by all the lawyers of all the European countries, and we need to translate that into Russian legalese. We are trying to be very cautious and attentive while doing this work, because it seems that this document helps to form a proper legal outlook. Professor Mubarak, Kleive and Varlov, members of the working group, they prepared an introductory remarks to the Russian edition, and in the near future as fast as we can, our legal community will get this document, which is a very good illustration of those principles that modern private law is built upon. This is the principle of good faith, the principle of reason or rationality, and the principle of educated choice or informed choice, and possible consequences of this informed choice. In the light of the opportunities our today's world offers in terms of sources of information. And the third thing I wanted to point out, and here I will say the following, and my words are inspired by what Anton was talking about. He was talking about a muddy torrent of draft laws. I would like to clarify that. It is not muddy, it is painstaking. It is torturous, because seeing those texts that are submitted to the Council on Codification, you cannot but feel some pain, because in spite of the huge amount of work carried out by the Council on Codification, acting as a filter, as a dam that is trying to stop this torrent, still it is clear that many draft laws will end up in the Parliament and then come out into being in an illegally horrible state. I cannot but refer to Article 405, that is the law on collateral, which has been amended. It cannot be applied. There are contradictions in the same article. There are ideas that contradict one another. The terminology is not clear. Of course, it is clear that it was written by laymen, even out of probably the best of intentions, but this law, unlike a bad product, cannot be thrown out into the garbage dump. We need to consume this low quality product. You know why I'm talking about all this? Mildly speaking, I'm surprised why the bodies of executive authority, and primarily the Ministry of Economic Development, why the State Duma, why don't they fulfill the provisions of the presidential decree? In accordance with this decree, the laws that contain private law provisions must be submitted for consideration to the Council of the Codification. Decisions by this council are not mandatory, but of course they have a lot of professional significance. This council can help to make the law technically more applicable, but in spite of these provisions, quite a few draft laws end up in Parliament, bypassing the Council for Codification. All the laws related to collateral bypassed this council and were successfully approved by the Duma, and nobody is concerned by the fact that these laws were approved in violation of the procedure prescribed by the President. Why it happens, it is a separate issue, but until real experts are involved in the preparation of bills, of draft laws, the fight for provisions of the civil code and the outcomes we expect from the new upgraded civil code will not be in line with our rightful expectations. Thank you very much. Benjamin Yakovlev, just a couple of words. It's a brief intervention. Working on the amendments to the Civil Code, and this work has been underway for 4 years now. I don't know a comparable example where such work would be performed on such an open platform, open at least for the professional community. The decree is well known. The concept of the new code was widely publicized, and the draft law was published in many places, and it exists in many sources of information. We held a huge number of discussions, and all this work was performed by people who have their main work to do. So, and these numerous discussions, numerous amendments, numerous proposals were processed. Those were 4 years of work involving all the interested parties and the expert community. And for the Ministry of Justice, this final stage is probably most obvious, because finally the Ministry of Justice joined this work. The Ministry of Justice had to lead this work from the outset, in the first place. Well, people get involved in this work slowly. We received certain ideas from oil companies only now, when the draft law has already been submitted to the State Duma. Why? We have the best lawyers working there, in-house lawyers. But why were they silent for 4 years while the draft was available and published in many places? Probably the problem lies elsewhere. And now, the law on economic partnerships. The law is in contradiction with the existing code and the future code. This law, for some reason, was adopted easily. Were there any discussions? How many people were involved in the preparation? I don't know who those people were. The Council of Codification gave 2 extremely negative conclusions. No matter, it was still immediately approved by the State Duma. In the course of its existence, the Council considered 700 proposals to the code, and the majority received negative conclusions. Some bills died away, others were amended, but still some bills are forced through the parliament, in spite of negative opinions of those people who understand something at least about the civil law. So the procedure must be streamlined, it must be improved through our joint efforts, and I urge all the people present here and those who are absent as well. Thank you very much. Thank you. Finally, we managed to criticize the Ministry of Justice as well. Okay. Now, we are already behind the schedule, but still we will have some coffee break now, followed by roundtable discussions on intellectual property, on corporate law, on contract law, on in-rem law, and international private law. Probably someone will, well, I don't know, but they will be held somewhere around here. All the biggest halls are used for these discussions. Well, there are no knowledgeable people somewhere, and they will probably guide you to the right round table.